This lecture is held every year at the law school to honor Nobel laureate and Clifton R. Musser Professor Emeritus of Law, Ronald Coase, and is supported by a grant from the John M. Olin Foundation and by the newly named, this is the first lecture since we named the Coase Sandor Institute for Law and Economics. Now, law and economics was a discipline that was born here at the law school, and Ronald Coase was, as many of you already know from your coursework here, as well as perhaps your education prior to coming here, one of its major pioneers. Perhaps the best-known article that Ronald wrote, The Problem of Social Cost, was published in the law school's own Journal of Law and Economics and is the most cited law review article in history. At age 102, Ronald is still actively pursuing his research agenda, something that we should all be so lucky to do. He's living in Chicago, just recently published a co-authored book entitled How China Became Capitalist. And indeed, Ronald will be here in March when we have an event to celebrate the naming of the Coase Sandor Institute, and will hopefully participate in some of the events that day here at the law school. Now, when Ronald came to the law school in 1962, law and economics already had a foothold, but he expanded its influence so that the law school became the dominant school in this area shortly thereafter and has remained that way ever since. The discipline spread to every law school and economics department in the country and has now become, perhaps thanks to our own program, internationally known. And it's a way of rethinking U.S. legal systems and the law and how they've transpired, how they've taken place over the past 50 years. It is indeed striking to sit in a faculty meeting and hear legal scholars of all stripes, of all disciplines, talk about the language of incentives, preferences, markets, and utility maximization, as well as other norms. Now, perhaps the major insight of law and economics, besides the Coase theorem, that, of course, Ronald will actually deny that he ever came up with the Coase theorem, so you should always understand that when you talk with him, but it's something that, for those of you who are students, you should have memorized already. It is the application of social scientific tools to research in other legal fields. For example, quantitative and econometrics have become the norm in many fields of study, not just economics, but sociology, political science, and other disciplines. For this reason, I and many others, I'm especially delighted to welcome Tom Ginsburg, the Leo Spitz Professor of International Law and the Ludwig and Hilde Wolf Research Scholar and Professor of Political Science today to give the Coase lecture. Tom is distinct among many of our Coase lecturers because he is someone who, in addition to using law and economics as a method, does a significant amount of comparative and international law using legal scholarship, using social scientific methods. His work is interdisciplinary. He typically works on research involving comparative constitutions and is a wonderful example of the dialogue so unique to the University of Chicago between law and economics, political science, and other disciplines. And a story that I sometimes think about is, before I came here, I was dean of another law school, and we looked at all of the scholars that we could get who knew something about international law, and Tom was at the very top of my list. At that time, he was visiting here. He broke my heart and came to Chicago instead of the school that I was at, so that led me to have to come to Chicago so we could be reunited here. In any event, I am so pleased that Tom is on this faculty, that his scholarship is of such a high level and really delivering enormous insights into international comparative constitutional law. Now, following Professor Ginsburg's lecture today, I'd like to invite all of you to join us out in the atrium where we will have refreshments and engage in continued discussion. But for now, I'd like to introduce Tom Ginsburg to deliver the Coase lecture.
Thank you, Mike, and thanks to all of you for coming today. I know the lecture is supposed to be directed at first-year students, and many of you first-year students will have already been introduced to constitutional law through the method that we usually use to introduce it to students, which is to have you read cases. This is the way that we teach constitutional law in law schools. It's the way we think about constitutions. I sometimes analogize this focus on cases and case law as somewhat like a baseball fan. A baseball fan who shows up at a baseball game around the 7th inning, watches the inning with intense concentration, focuses especially on the umpire, the balls and the strikes, and then when the inning is over, the fan leaves the game. That is, when you look at a case, when you read a case closely, you are looking at the umpire, but you leave, you don't see what happens after the case is over. We often don't spend much time looking at the actual implementation of decisions. We also don't spend much time talking about the political and social interests that are at dispute in any particular case, nor the even more fundamental question, which is constitutional order. Where does it come from? Now, when one is looking at a comparative context, I think it's especially important to focus on the game outside the 7th inning. And to do that, of course, requires tools outside law. You have to use the tools of social science. And the reason it's so important in a comparative context is because one cannot always take constitutional order for granted. It is not obvious in many countries of the world that court decisions will be obeyed. It is not obvious that judges will be deciding them in a kind of neutral way. And so this requires broadening our lens. Now, of course, there's many social sciences one can use. And economists have been focused on constitutions for some time. And they've come up and made many contributions to the study of constitutions. Economists tend to focus on the functions of constitutions. What do I mean by the functions? Well, from an economic perspective, of course, government is a device for generating public goods, those goods which cannot or are unlikely to be produced in sufficient quantity on the private market, things like national defense or good environmental regulation. And of course, if government is a device for doing that, we need rules to structure government. A particular concern from economic theory is the idea of agency control. That is, the people who are running the government for us are in some sense our agents. We hire them to do some work for us. But as with any agent you hire, you have to make sure that that agent is going to be performing in accordance with your instructions and not simply acting on behalf of their own benefit. And so from an economic perspective, a lot of the rules of constitutional law and constitutions can be explained as devices to help govern the selection and the controlling of agents. Think about regular elections or criminal procedure rules, which limit what the police can do. Many of these things are quite understandable from an economic perspective from that point of view. Another idea that economists have contributed is the idea of pre-commitment. That is, it may sometimes make sense for us to limit our collective choices. This is not really about the agents we select, but as taking certain things out of the decision function, certain things that we cannot decide, because we are afraid that if we are allowed to decide these things, we might do so with our short-term interests in mind rather than our long-term interests. It might make sense for all of us, for example, to agree to confiscate Dean Schill's apartment and split up the proceeds among ourselves. But of course that wouldn't be good for Dean Schill. Nor would it be good for the society, because people in such circumstances would be less likely to invest in property. They would be less likely to invest in their own futures. And so many times constitutional rules take things off the table. Now these are all standard things out there in the literature, and they're all focused notably on the functions of constitutions. I want to look at constitutions from another angle, and that is not to look at their function so much as their form. And that's why I've titled this Constitutions as Products, right? If you think about it, products have functions, but products also have form. Take this cup, for example, right? It has a function, that's to hold water, but it also has other attributes which it might be interesting to interrogate. from the point of view of understanding the cup and trying to get a complete picture of it. It was produced in a certain way, right? And that might tell us something about it. We might want to know, for example, if it was mass-produced or if it was produced, as this one was, by hand by someone. That might make a difference in its value and such. And similarly, we can look at constitutions around the world from this point of view. We can look at the production process and see if it has any impact on the actual product that is produced that way. The cup also has certain features, right? It's got a color, it's got a shape, it's got a handle. Some of these features, of course, go to the core of what the cup is, right? But some of them are quite peripheral. We could get rid of them, they're optional, right? We could change the color, it would still be a cup, probably even take off the handle. You could change the shape a bit, but if you change it too much, it would no longer be recognizable as a cup. So using this idea of core and peripheral features, I want to interrogate what it is that really is the essence of constitutions, or what is conventional, if you will, to put in the product called the Constitution. In addition, constitutions, like the cup, have substitutes, right? That is, if I want to drink water, I can drink it out of a cup. I can also drink it out of a glass. Pretty much the same function. There are many things out there, many kinds of institutions, which will play a similar functions to those that we've identified for constitutions, right? That is, if we want to control agents or we want to tie our hands, there's other sort of technologies out there which are available to us. We could use norms, for example. We could have unwritten understandings that would function the same way to limit the people we select to govern us. We could rely on case law. We could rely on statutes. We could rely on a political program and a political party to control agents and such. So there's substitutes for what constitutions do. But there's also some features which seem to be quite essential, right? And so the fact that there are substitutes doesn't mean that there aren't sort of a core set of attributes of a constitution. One way that constitutional scholars have talked about this is to contrast the small c constitution, those various things which are outside the formal written document, with the large c constitution, which is the single document that most countries have. And I want to focus on that, actually. I want to focus on the latter. So I recognize that the product, which I'm going to call a constitution, the written formal constitution, is obviously not the only thing which can play the function, but I think it will be interesting to interrogate its features nevertheless. Now, one final introductory point. What defines a product is a certain kind of mix of function and form, right? So suppose my cup here had a little hole in the bottom. It didn't serve its function. It was unable to hold water. If I held it up, most of you would still identify it as a cup, even if it was leaking water right on me. Now, what that suggests is that it's some combination of function and form, right, which would be the essential defining attributes. If, however, we were to change the shape of the cup, or we might significantly, it might have the same function, but no longer be a cup. Let's say it might be a bowl. So the point is that it doesn't have to work to still be a constitution, right? In fact, what's one of the things I want to interrogate? Under what circumstances do constitutions make a difference for actual behavior? Under what circumstances are their provisions actually followed? The cup, pretty durable. It's made of ceramics. It'll last forever as long as I don't drop it. If it was made of paper, it would not, right? So that's one other feature we might look at when we interrogate constitutions as projects. Some of them last a long time, some of them don't, and I want to ask what are the things which allow them to focus, to be more effective. Now for all of this, I'm drawing on a large data project that I've been running for several years. A couple of you in the room have actually worked with me on it, and it involves looking at the contents of written constitutions across time and space. The effort's ambitious. It's to look at every constitution ever written for an independent nation state since 1789 for all independent countries. For most countries, it's pretty easy to identify what this is. There's a single written document called a constitution. There are a small number of countries which don't have them. Israel, for example, has a series of basic laws. In Saudi Arabia, the position is that the constitution is the Holy Quran. So man can't make constitutional law. For countries like that, we have a secondary decision rule. That is, if the law is called a basic law, a Bill of Rights, or if it sets up a branch of government, we call it constitutional. For virtually every analysis we've ever undertaken, you can throw those countries out and it still results seem to be quite robust. I should add that the United Kingdom is the one country which I don't include in the analysis. Every time I ask a British constitutional lawyer, what is the British Constitution, I get a different answer. So I figure if they can't figure it out themselves, I'm unlikely to be able to improve on that. All right, the Constitution as a product has been an incredibly successful one. If you analogize countries to firms, right? Firms can choose to use any particular kind of governance technology that they want. But constitutions, formal written constitutions, are a really popular one. This figure gives, for each year since 1789, the number of new constitutions, from 0 to 25, written in any particular year. The top line here, the dark line, is the number of countries in existence in the world. And as you can see, it's roughly quadrupled since 1789, breakup of empires and such, many new countries. The bottom line here is the number of countries which have a written constitution. And so you can see at the outset of the period, it was quite rare. United States, France, Poland, a couple of countries. As time went on, though, the two lines converge, right? So that now every new country that comes into existence is likely to, as one of its very first acts, write a new constitution. Indeed, many countries are preparing constitutions in advance of becoming independent. Scotland just announced this week that this is their program. They're trying to become independent of the United Kingdom, and so they're preparing a constitutional draft just in advance. So the point is that the product has been incredibly successful, and that's a kind of interesting thing to try to understand. I want to look at the production process a little bit, so I want to start with that. How are these things produced? In any given year, there will be 5 or 10 constitutions produced. There are various kinds of ways that one goes about this. Sometimes they'll just be written by a very distinct or a very small group of government elites. The Constitution of Burma, passed a few years ago, was written by just a handful of people in secret. No one knew what was going on. In other cases, they're adopted in very open processes. That is, they're produced in constitutional assemblies which might have been elected by the public. They might have public input. And they might even feature, at the end of the process, a kind of public referendum, an up or down vote on whether or not the Constitution should be brought into force. So there's a great variety of mechanisms. One way just to contrast is to illustrate the extremes might be to look at the Constitution of Egypt, which many of you will have noted was passed in December in a very kind of violent process in which the majority decided that it didn't want to include other voices and rammed through a constitution of dubious constitutional legality itself right before a constitutional court could declare the process unconstitutional. That's a kind of pure majoritarian model, and that's one approach. At the other extreme, you have very open processes. Iceland, for example, last year has adopted a constitution in a very novel, very 21st century way. They were quite upset with their government as the whole country was sort of a giant subprime mortgage problem in and of itself. The economy collapsed after the great financial crisis of 2007 and 8. And the people were very angry. So they set up a process to draft a new constitution. They first randomly selected 1,000 citizens to generate ideas for what this constitution should contain. They then held a public election in which anyone could run as long as you were not a politician. And then those people then drafted a constitution which was put before the public again in a referendum, and it may be passed later this year. So that's a kind of the other extreme, a very open process. By the way, they had a Facebook page and somewhat of a wiki process where people could contribute to drafts in a kind of very open way. So this is the 21st century model. Does it make a difference? Well, it's hard to know. The traditional view, of course, is that constitutions are going to be written by statesmen, right? James Madison, Alexander Hamilton, you have these great figures acting in the public interest. You know, the economists who've worked on constitutional design tend to be very skeptical of that, right? Economics, of course, is about incentives, and we're always very skeptical of the idea that anyone might be publicly motivated. And so there's somewhat of a tension. In particular, if constitutions are designed to limit agency costs, right? If they're designed to produce good governance outcomes, there is a kind of prior question as to how we get a constitution that will do that. notwithstanding the fact that it's also produced in a political process, right? That is, why don't agency problems also exist at the constitutional level? There is an assertion, in the constitutional literature that constitutional politics are truly different, that they are higher order. But I wonder why we would think that. Well, one reason we might think that is that constitutions are, of course, great symbolic documents, and they're adopted in very public ways. The visibility might itself serve to constrain agency costs, right? Because everyone can see what's going on. Everyone will be motivated because of the high stakes to watch. It also might serve to facilitate group organization, right? So another staple of the public choice literature is that groups, large groups such as the public or taxpayers or consumers, it's very difficult to organize them because their individual stake in any particular public choice decision is very small. If the Constitution is at stake, though, you might be able to overcome some of these collective action problems, which might lead to constitutional politics being of a different quality. On the other hand, you might rebut that by saying the very fact that the stakes are so high might increase the incentive for interest groups, for private interest groups, to also mobilize, right? If you can get a rule into the Constitution, well, then that's going to be a very valuable one, and it's going to be entrenched. And so you're likely to see some great effort to organize and great expense to be exerted in terms of trying to get rules into the Constitution. So there's a bit of a tension in the literature. But I do think that one implication of all this is that the more open processes, the more Iceland-style processes, are likely to produce, if you will, better documents, more open documents, ones that are likely to involve the public down the road. To test this, I and some colleagues looked at, tried to relate process with outcome, process and product. So we categorized constitutional design exercises in a variety of ways. We asked if it had a constituent assembly, if there was a public referendum thereafter, whether it was executive-centered, and we looked at the outcomes, looking at the contents of the constitutions that were produced in these ways, and tried to examine whether we could find any relationship. Interestingly, we didn't find many relationships. And this is somewhat surprising. I mean, there's become a norm to think that participation is always good. But we did find two things in particular. First of all, those constitutions which were dominated by the executive in the production process tended to produce executive-dominated governments. That's not particularly surprising. Similarly, those constitutions in which there was a public referendum at the end of the process tended to involve more instruments of direct democracy down the road. So public involvement in the production process leads to public involvement in the product. And so that's a kind of relationship which seemed to hold. In addition, when the public was involved, there did seem to be a greater number of rights in the Constitution. So that suggests that there may be something good about participation, that it might be able to overcome some of the the problems that one might think of using the simple economic theory of that the Constitution makers are likely to be motivated by self-interest. Another question I've been interrogating is innovation. Innovation. If you think about a product, right, we understand somewhat about where innovation comes from. If you can design a better cup, a cup that looks better, is more attractive, wouldn't be too hard, a cup that is more durable, perhaps one that holds water in a more efficient way, right? You're likely to do so in a market setting because you're likely to be rewarded for doing so. Constitutions and public choice generally doesn't have this advantage, right? That is, the fact is that there's no ongoing revenue stream for the designer of a constitution, nor do they necessarily get much credit for their work. There's no intellectual property right that we know of in public law. In some areas of legal production, I think this is resolved by the concept of reputation. So if I'm a judge deciding cases, I might want to have a reputation for being an innovative judge, and I might come up with good legal rules, and that might be good for me down the road. Similarly, we sometimes have legislators who take the lead, they get to claim credit before their constituents, they put their name on the bill. Constitution makers, by and large, are not in this category. They're mostly people who do this one time, they'll never do it again. They're mostly faceless people, they're sometimes technocrats. For every James Madison that's out there, whose name everyone knows, there is Jared Ingersoll, who I'm sure no one in the room can identify, but was one of the signers, one of the designers of the American Constitution. So there's a lot of, it's not clear that people are going to get a kind of reputational benefit. And that, I think, is a general problem for public law, particularly difficult in this context. Furthermore, the way Constitution writing works is different from other examples or other things we might look to in comparative law. Famously in corporate law, right? We know that in the United States, corporate law is a feature of state law, and there's a lot of theory out there about how competition among the states will induce lawmakers to produce better law, right? There will be a race to the top in some theories, others think there will be a race to the bottom. But the point is that competition over mobile population, corporations or citizens, can induce better law, right? Can induce innovation, good innovation. We don't have that in the case of national constitutions. The other thing is that we're operating in an environment of tremendously incomplete information, right? It's very hard. What you're doing when you're writing a constitution is picking a set of institutions to apply to a particular context. We know very little, really, about what it is that makes some things work in some contexts and not others, right? If you adopt an institution that works, you don't really know if that's a feature of the context or a feature of the institution. And social science, I have to say, has not done a particularly good job here. The entire discipline of comparative politics has been fighting for 30 years about the merits of presidentialism and parliamentarism. And the current state of knowledge is that, well, we don't really know. It doesn't matter much. Or we can't tell that it does, we're not sure that it does make a difference. So imagine you're a constitutional designer and you're operating under this great circumstance of incomplete information. It's unlikely that you're going to invest much in coming up with novel institutions. It's unlikely that you're going to necessarily produce a very good set of choices. It is true, though, that we're operating also in a global environment. And so most constitution-making processes today involve international actors in which there are people who are international organizations who are promoting their particular point of view, the United Nations and such. You might view this as a kind of subsidy for certain forms of knowledge, subsidizing certain positions, making them easier to adopt. But all in all, my suggestion is that there's likely to be a kind of underproduction of new innovations, that we stick with the institutional categories, the institutional menu that we've inherited, and there's probably too little innovation, certainly relative to a private market, where again, producers are likely to have an incentive to try out new things. One implication of this is that constitutions are likely to be similar in a particular context across time, and that's one thing we observe. So in these figures, what I've done is look at look at the features, 100 different variables for a particular constitution, and compare it with for any particular constitution with its predecessor. Okay, you could do this for any two dyads. I could take any two random constitutions out of the pool and compare them, and it would be likely to they would likely to have some correlation, but not a very high one. One way to think about this is a correlation, and the baseline level is about 0.6, about this level. When you look within a country, so this will represent Brazil's constitution of roughly 1900 relative to the earlier one of the 1860s. Venezuela's had a lot of constitutions. But the point is that these figures, these dots are all pretty high, right? That is, once a set of institutions is adopted in a particular country, it tends to be somewhat sticky. It tends to last. And that itself is interesting and worthy of interrogation. It suggests, again, that because maybe these are not sort of optimal situations with it, it's hard to tell. But the fact is that we don't really, that constitution makers seem to be sticking with the choices they know, notwithstanding great changes that are going on in these societies. Sometimes a society will move between a dictatorship and a democracy. Most of the institutions will stay really quite stable. The other thing is that if one looks at the entire corpus of products, there's a lot of stickiness. There's sticky defaults, as I put it. The American constitutional designers, when they came up with their design, they decided that the president should be at least 35 years of age and legislators should be at least 25. Probably a pretty undemocratic thing, actually, if you think about it. There's not that much rationale for limiting it. But in any case, that's what they did. it turns out that to this day, that is still the most common number to put in there as an age limit, notwithstanding the fact there's been tremendous improvement in life expectancy since the 18th century, right? There's a dramatic change in underlying circumstances, yet we stick with the rules that we came up with, and other countries seem to borrow it and seem to copy it. It's a pretty minor thing, and so not much incentive, I suppose, to invest in fixing it. One thing I was looking at recently is phrases in preambles, and it turns out "we the people" is a tremendously popular phrase, and perhaps not surprising, but that over time it's risen and fallen. Now it seems to be quite a norm. Notwithstanding that, there are occasionally new institutions that come into being, new technologies one might think of, and one might track their spread over time. So this looks at the institution of independent regulatory institutions, things like the Federal Communications Commission and such. And in many countries, these are constitutionalized. One of the things I'm puzzled over and struggling with, it's more of a question than an answer then for now, is why things which are invented in a very early period take quite a while before they take off. But it's not an uncommon pattern. We see an innovation that occurs, but innovation, of course, is separate from the diffusion or separate from the spread of the institution in terms of popularity. And we often see a big gap, and this is true here. So the point is that there is some innovation that occurs. It's not clear how much, and it's not clear what the forces are that cause countries to borrow institutions from abroad. We're not really sure if when independent regulatory institutions spread, for example, if that's a function of learning, right? If that's us collectively getting better as a new handle design might spread in the world of cups, or whether that's simply just a fashion as a new color might be if that were to spread. And that's a kind of a research agenda really going forward, is trying to figure out what is the factors driving diffusion. One of the great trends in form in constitutions is the spread of rights. So here I have time on this axis, the number of rights in any given constitution found in particular countries. And what you see is that line over there captures the trend that over time there have been more and more rights in national constitutions. There's greater variance, I suppose, but certainly more rights. And so that's certainly a trend. This one, I think there is somewhat of an explanation. And I think part of it has to do with the transnational context in which constitutions are increasingly produced. If one looks at the menus of rights adopted by national drafters, and one compares them with international instruments, Universal Declaration of Human Rights, the International Covenant of Civil and Political Rights, one sees a lot of convergence. You might think about this in terms of a kind of a boilerplate set of rights that are adopted by constitution makers from abroad, but it might also, of course, be a product of some sort of subsidy or lobbying that occurs from outside. But it's certainly a big trend and one that's worthy of explanation. Again, there's a large difference between rights that are, between the time a right is innovated, if you will, a time it enters the corpus, and its subsequent spread. So let's just to look at a few different rights. Right to freedom of expression is always very popular, starts very popular, and stays that way. Right to health care sort of emerges in the early 1900s and really takes off after the 1950s. It's kind of considered a second-generation right. The right to education is also considered a second-generation right, but notice that it's popular much early on. It's really takes off earlier. And finally, there's the one in the news these days, the right to bear arms. In the early 1900s, a lot of countries were just copying the American template, if you will, and it was fairly popular. Over time, one might say they've learned. Others might say that they're just following some international fashion. But it's certainly the one right in our Bill of Rights which has decreased in popularity over time. All right, so all of this goes to the contents of constitutions. And I want to just step back a little bit and think about the determinants of this. As I said, there's a lot of stickiness in terms of the first institutions you adopt, but there are also these kind of time pressures, right? And that might affect, if you will, the shape of the constitutional product. In this figure, what I do is I look at the popularity of particular features over time. And one way to realize it's hard to read for those of you in the back, but this column here looks at the percentage of constitutions in force which have any particular provision. So does the Constitution require oaths? Very popular now. It has trended over time, and you can see that oaths have always been a kind of core feature, if you will, of the constitutional product. Same with provisions on amendment. Other things, though, which are now very popular, have really only become popular later. So does the Constitution refer to political parties? In the 19th century, very few constitutions did so. Now, many constitutions do, and it's become a kind of norm. And again, we don't know really if that's a response to trends or just borrowing, or if that's actually a kind of learning. My guess is the latter. Political parties weren't well known in many countries in the 19th century. As they've emerged and they've taken on a kind of constitutional function, the products have responded, if you will. One could compare this with things which are much less core. They're the equivalent of the color or the handle design of the cup, right? They're optional. They're not essential features. Does the Constitution contain a motto, for example, I ask? Well, some of them do, about 20% in force now, and it's been pretty constant over time. Does the Constitution refer to a specific individual? Well, it's interesting. A lot of many constitutions do. The Chinese Constitution mentions Mao, and the Vietnamese Constitution mentions Ho Chi Minh. Few constitutions mention Jesus or Muhammad. So this is but it's not a very popular thing, 9%. It's not what we would call a core feature. Sometimes you have things which were not core features, but now seem to be on the rise. A Human Rights Commission was invented really in 1986 and has started to take off. Victims' rights is another one, which seems to be a trend in that direction. On the other hand, some things are disappearing from the corpus. Bankruptcy law, for example, used to be a big thing in constitutions, and that's because, of course, they used to lock up debtors, and so it was a major human rights issue. Once we stopped doing that, much less pressure, I suppose, to constitutionalize it. Now, the point is that there are certain features which are core, certain features which are peripheral, and they're not necessarily corresponding to what you might think of as the essential functions, right? The form is quite different than the function. And the form seems to be produced in a process which is somewhat unrelated to function, very much like a product, right? There are trends in fashion which will dictate the shape and the style of the cups for sale in any particular time. Similarly with constitutions, there are trends. When you look at all of this, when you look at all sort of analyses of the contents of constitutions, there are three things which really stand out in terms of the determinants of any particular document or of any particular product. The first is the era in which the document was written. Time seems to be really important. And again, that seems quite intuitive from the kind of fashion perspective or the thinking about products. Region is also really important. There are regional trends in constitutional design. And so countries are likely to be more similar to those that are their neighbors than those that are not. And finally, the first constitution in the country's history. That seems to have a lot of sticking power. And when you add all those up, really the essential question then is when does the country sort of enter the international system? When the period and the region in which it does that is going to dictate a lot of the contents thereafter. All right, now I want to turn to another topic, which is duration or endurance. And of course, the cup, as I said, will last forever. If it was paper, it would not. We tend to think of durability as being important in some products, but not others, right? And products obviously vary in terms of how long they will endure. Wine seems to get better for a certain amount of time, and then it gets worse. Some products, again, will last forever. So one question we have to ask as a threshold is whether or not duration is good or bad, right? Whether we want constitutional products, if you will, to last a long time. This is something that's been debated intensely really since the era of the Founding Fathers. Our own Thomas Jefferson, for example, thought that constitutions should not last a long time. His view as a radical Democrat is that the dead should never govern the living, and so that all constitutions should die at the age of 19. They should be torn up. And then we, the people, would discuss them again. If we chose the same institutions, that was okay, but we would be forced to make our own choice. And that was his position. He got the 19, by the way, from a table of European life expectancies at the time. He did the calculus for when today's majority would be replaced by tomorrow's. So that was his view. You might sort of intuitively say that that does make some sense for some context, right? We know that products are purchased, but the world changes, right? And these exogenous sources of change might mean the things that you buy no longer fit. How many of you people over 40 will still fit into a suit that you bought when you were 20 years old? Probably not very many. Something's changed, and you might need to buy a new one. And so the constitutions, I think, have the same feature. One example I often use is the Constitution of Lebanon, which in the 1940s decided on the basis of the current demography that offices would be divided up among Sunni, Shiite, and Maronite Christian. The president was going to be a Maronite, the parliament speaker a Sunni, etc. And this made a certain amount of sense at the time. It was kind of bargain that was produced in a contractual setting. And on the other hand, of course, it should have been foreseeable to those folks that the demographics of the time might not be stable. And indeed, they were not. The Shiites, it turned out, had many more children than the others, and there was pressure, if you will, on the bargain in order to change. The pressure led to a bloody civil war. So that's an example of a constitution which would have, in some sense, things would have been better had there been a kind of forced renegotiation after a certain amount of time. So that's sort of the Jeffersonian view, that they ought not last a long time. On the other hand, there are those who argue for stability as an inherent good, a kind of Burkean view. Or one might think about it as, sort of from an institutional perspective, as the value of stability on other institutions, right? So we know in modern democracy that many of the things that help democracies to work and to function are not going to be found in the four corners of a constitutional text. Things like political parties or a free press or an independent judiciary. Some of those things might be influenced by the text or by the institutions adopted in a constitution, but a lot of them involve sort of collateral institutional development, right? And for those things, change that occurs in the fundamental institutions too frequently is likely to lead to great disruption. Furthermore, adopting a constitution is a costly thing. The negotiation isn't easy, and that's kind of sunk cost every time you do it. So from that point of view, we might think that constitutions ought to last a long time. Well, what would an economist say? I suppose one thing we might look at is what works, right? Empirically, can we identify any things that are associated with or perhaps caused by long-lasting constitutions? And this figure gives some information on this. So this, for every constitution in the nth year, from 0 to 50, this is the average level of wealth for all countries, the average level of democracy for all countries, reaches 0 right here, the average level of political stability, and the frequency of crisis is defined in the literature. And what it suggests is that it's good for many things to have a long-lasting constitution. Now, we're confronted immediately here with a problem which empiricists will recognize, which is this is probably a situation of reciprocal causation, right? It's not necessarily clear that just because your constitution lasts a long time, you will get longer democracy. It's likely that having more democracy is going to contribute to constitutional endurance, right? So this is just a mere correlation. But it's a suggestive thing which certainly invites further inquiry. When one looks at duration, one sees great variety. And it seems to be, there are very many different kinds of national patterns, right? So the United States looks like, each color here in this figure, I should say, is a different constitution in the country's history. Some countries are like Australia or the United States, single document. That's pretty rare. Really common pattern is Mexico, where you have lots and lots of experimentation with institutions before you get a stable constitutional bargain. Panama looks a lot like Jefferson's fantasy, right? They seem to change the product, if you will, pretty frequently, about every generation. And some countries, like the Dominican Republic, just can never get it together. Indeed, I want to show you a figure. Each year up here is a different constitution in the Dominican Republic's history. This is the level of democracy as measured by political scientists, and what you see is that they're changing the product, it's not having much effect, right? It would be nice if I could show you a figure like this with a country that had a lot of constitutional change and a high level of democracy. It doesn't seem to be out there. So it does seem to be something about this endurance feature for democratic performance, I think what I'll do is go to this slide. One way to think about this is how durable is the product? How likely is it to live? And one thing we might look at is what economists call hazard rates, right? So a hazard rate is basically a level of risk. If I was to look at the hazard rate for a human being, right, this shows you sort of the probability of death over a particular age, right? So for a human being, we have a high hazard rate at infancy, right? There's a lot of infant mortality. If you can survive to age 2 or 3, I think it is, you're likely to live for quite a while till you get to whatever it is, age 70 or so, in which case it would spike sharply upward, right? The older you get, eventually we all go. That's not true of constitutions. The risk seems to be highest early on, but then if you can make it to, say, age 100, it's likely you'll live to be forever. Now, the confidence intervals indicate that there's not very many countries in this category, but it does suggest that these things are not quite like human beings, that they are enduring once you can survive some risk at infancy. In a book I published a couple years ago, we examined what are the causes of endurance and the likely correlates, if you will, and we used a whole bunch of statistical models called hazard models. I'll just summarize them for you. Rather intuitively, we put these things into 3 categories. If you think about the product, right, a cup can be well-designed or not well-designed. There are certain things which will happen to this which will break any cup, right? A nuclear bomb is going to destroy it. Shocks are what will cause the death of constitutional institutions. External shocks like war, economic crisis. And we indeed found that defeat in war or coups are likely to lead to the death of constitutions. Interestingly, though, we also found that there seemed to be a trend in replacing your constitution. So if all of your neighbors were replacing theirs, even controlling for things like wealth, controlling for all other factors, is still more likely that you're going to adopt a new constitution yourself. So again, an analogy to fashion is pretty easy. If everyone on the block is doing it, I'm going to start wearing a pink suit as well. There are features of the product itself which would matter, right? Or not of the product, but of the country, right? Richer countries tend to be more favorable soil, if you will, for enduring constitutions. Those with lots of ethnic groups tend not to do so well, at least if they're dictatorships. They do better in democracies. The key question for us, actually, though, in thinking about products and in thinking about the takeaway from all of this for law and for normative kind of thinking, is there anything you can do in the product design that will make it more enduring? Is there a way to build a better cup, if you will, better materials and such? And we identified 3 factors which are within the control of constitutional designers which seem to facilitate endurance. The first is flexibility. It's very intuitive, right? If you're in a world which is always changing, you need a document, a constitution, which also can change. And we found, generally speaking, that constitutions with lower amendment rates tended to, with simpler amendment rates, right, would be easier to change when things change and thus would be more enduring. We also found, in that regard, that countries which had constitutional review seem to have enduring constitutions as well. So the court is a kind of mechanism, if you will, to facilitate constitutional endurance, to facilitate flexibility. And that's quite consistent, I think, with conventional understanding. A second feature was inclusion. It's much better to be like Iceland than to be like Egypt. I predict the Icelandic constitution will last longer than the Egyptian one. The Egyptian one might not even last this year. But if the Icelandic one is adopted, I could plug it into the model. The model predicts it's going to last 60-something years. It's adopted in a very open way, and this seems to be important in the sense of giving interest groups, giving the people a kind of investment, or if you will, in maintaining the constitutional bargain, so that when it's subject to some sort of challenge, they want to protect it. The final feature is rather counterintuitive for Americans, and that's what we call specificity. It really reduces to the level of detail. Oddly, the more detailed a constitutional document is, the more likely it is to survive the storms to which it will be subjected. And again, that's quite counterintuitive for Americans. Our theory is that this has something to do with sunk investment, right? That is, if it's costly to write a constitution, and it is, then the more detail you have in there, in some sense, the less it's going to be more costly to replace. It also means that particular groups are likely to have significant benefits that flow from that Constitution. In a way, this goes back to where I was starting, and it suggests that interest groups may actually have some role to play in facilitating constitutional endurance. When you have a challenge to a constitutional order, it's good if you have a certain amount of interest group activity, of interest groups that will want to preserve it and fight for it rather than renegotiate another one. And when one looks at particular cases, this seems to have it seems to play out. So, for example, the Constitution of Mexico has been very enduring. It's survived a transition from dictatorship to democracy. It's a very detailed constitution. It's got a long labor rights provision, which is being changed all the time in giving the labor unions, which are a big part of the coalition that runs Mexico, more and more benefits in the Constitution. And this, I think, is one of the reasons that there was kind of agreement not to rewrite when Mexico became a democracy. The labor unions were worried about losing things. India, another example of a long-lived constitution, which is flexible, certainly. It changes every year. But it's also got a lot of detail about sort of rights that are going to be given to particular groups. And so this seems to be somewhat counterintuitive, I think, for Americans. But these three factors of constitutional design seem to help the product, seem to help it endure over time in the face of complicated and changing circumstances in the world around you. Now, I just want to say a word about the United States, because our Constitution, of course, is the most enduring. It's not very flexible. It was adopted in a very uninclusive process by contemporary standards, and it's not very detailed. Indeed, the world is full of constitutional consultants going around telling countries like Egypt or Iceland that they ought to adopt one that looks very much like the United States. I think this is quite wrong. I think in the book, we analogize the United States to a woman named Jeanne Calment. Jeanne Calment was a woman who died at the age of 122 years old in France in 1997. Her diet consisted of regular shots of port wine, olive oil, and 2 pounds of chocolate a week. She was a lifelong smoker, though she gave it up for a year at age 117, then went back after she decided that it didn't make her feel any better. So, whatever it was she was doing, may have worked for her for reasons that we can't explain, but not necessarily good advice if you're Egypt or Yemen or Iceland. And so that's our take on the United States. Now, I just want to say make one last set of points, and that has to do with constitutional efficacy. I started by talking about, would it still be a constitution if it didn't work? And if we think about constitutions having form as well as function, I think the answer is yes. But this then leads to the question of what is it that makes constitutions work? What is it that makes them effective? And this is an enormously difficult research problem, which I have not in any way solved yet. But I want to talk about why it's a difficult research problem in order to encourage those of you who are empirically inclined, and some of you first-year law students, to think about how we might get some traction on the problem. So I'm going to show you a figure, first of all. So this is an indicator. On this column, we have the level of actual civil rights protection, civil liberties protection in any given country, as defined by Freedom House. And here we have a de jure index produced from our Constitution's data set. And each one of these three letters here is a country. And so you can see that countries have very differing relations between what's in their on the paper and how things actually work in practice. Many countries have a lot of promise on paper, but don't deliver much in practice. This is Uzbekistan, Turkmenistan, Sudan. So paper doesn't seem to be doing much good. On the other hand, we have countries up here, Australia, New Zealand, United States is up here as well, where we don't actually promise very much relative to other countries, but we deliver a lot. We're overperformers, if you will. An interesting question for me is what leads countries to be on this line, on this sort of regression line, if you will. Up here we have countries that promise a lot and actually deliver a lot. Hungary, Portugal, Slovenia, Slovakia. These are countries which are, in fact, generally speaking, have democratized in the last 10 to 15 years. They've written a new constitution. to sort of codify their understandings of what democracy requires. They've adopted rights from the international instruments, and they seem to be following those things. Now, you might say that they would have this high level of rights protection without having adopted those texts, and that's the puzzle, right? Whenever we are trying to compare text and practice, we face and this is true generally in legal studies, but particularly with constitutions, we face the problem of how to handle missing variables, right? It may be that what happened, the fundamental change, which happened in Portugal in 1975, was that it became a democracy. Society changed, that led to a change in the text and also to a change in practice. That's what we would call a missing variable problem. There's kind of a missing variable which we're not able to look at, which we can't observe, which is affecting both the outcomes that we're interested in. It may also be that there's kind of a reverse causation problem, right, where a country changes its practice and then changes its law, right? Or sets in motion some things which will change practice, and that then changes the law. So that's another empirical problem that we confront. And it's very difficult, and there's a lot of statistical methods to try to sort this out. But I do think that it's worth interrogating what it is that leads countries to be around here. My own intuition is that, in fact, for certain kinds of provisions, we can identify some causality. But before I turn away from this slide, I just want to point out down here. So here we have countries which don't promise much and don't deliver much. Whatever you want to say about them, at least they're honest, right? You have Saudi Arabia down here not promising much, not delivering much. And that itself is a kind of interesting question. Why are some dictatorships like this and some like this? Another puzzle. Without trying to determine, or without really being able to fully answer what it is that leads constitutions to actually be implemented, I do want to make a final point, which is that we can compare the level of practice and the level of performance over time. And one of the things that we observe when we do that is that as a constitution ages, the gap between the level of practice and the level of performance actually grows. It becomes much more like these countries up here. These are countries that tend to have older constitutions. If you just focus on the gap, right, between the observed and the promised constitutional rights, ones that you might say, well, these have really large gap. And the interesting thing is that the gap grows over time. The older the constitution, the more you sort of move to this quadrant. So the gap grows, but it grows in a positive direction. We also can look at this not just for rights, but for institutional provisions. So there are ways of codifying levels of parliamentary power in particular contexts, levels of judicial power. And we observe the same thing, that over time, the gap grows between the level of parliamentary or judicial power in a constitution and the level of actual power in any particular structure, constitutional structure. And it turns out that they also grow in a positive direction. It suggests, again, that there is something about endurance which might have some tie to efficacy. Well, just to conclude, Constitution is clearly a very successful product in terms of doing what they're trying to do, and in thinking about them as having form and not just function, right? One can interrogate the particular production processes which lead to particular constitutional designs, and one sees that process does seem to matter, at least in some circumstances. In particular, inclusion seems to be a very important trend in constitutional design, and I think a positive one in terms of values of democracy and rights. Another point is that when one wants to understand the contents of constitutions, you can't simply look at the local context. Although we, the people, come together and we think of constitutions as being expressing our fundamental values, there are trends across countries, there are trends over time, there are trends in regions. And these things are going to likely influence the shape and the design of products, right, of the constitutional product. Just as with fashion or with cup designs, we're likely to see things that are very difficult to trace, but that do come from outside the designer themselves. Finally, in terms of constitutional endurance, I want to leave you with the idea that they seem to endure most when they are least constitutional, right? As I said, if a constitution maker produces a document that's flexible, that's relatively detailed, right, that's inclusive, it's likely to endure. In some sense, that suggests that constitutions are likely to last more when they're much more like statutes, right? When they involve interest groups, when they provide benefits to particular groups who will have a stake in their endurance. You need to get the producer, in some sense, involved and have an interest in the product in order to make it endure. Finally, the final point is that sometimes the old products are the best. And with that, I will close and look forward to your questions and comments.
I didn't notice you saying much about federalism or other issues of subnational units.
Yeah.
And I guess the second question is, I'm just wondering if there's some implicit move you're making that lasting a long time is good, whereas it might be better to have, might be constitutions achieve more of what they're supposed to achieve when they don't last a long time and they're replaced.
Right. So in terms of the second point, there's obviously a lot of different purposes, right? Sometimes constitutions are designed to resolve a particular political problem in a very short-term kind of way. We have an ethnic conflict, we want to stop that war, and the Constitution will have the character of a peace treaty. And I think that for that kind of situation, lasting 5 or 10 years is actually a sign of great success. It's longer than the modal survival rate and probably not a bad idea. I think that it's hard to evaluate universally, but that being said, I am sort of looking at averages across all countries and suggesting that on average, it is generally good to last a long time, though of course it might be context-specific evaluation. In terms of federalism, it's quite interesting thing about constitutional design. The number of countries that are formal federalisms is actually relatively small. The number of countries with highly decentralized government is going through the roof. It's a major trend in constitutional design is to sort of implement what we call in the literature subsidiarity, to try to locate decisions about public goods at the lowest level possible. And so this is something where I think looking at a category like federalism or non-federal actually is not that helpful. It's a little bit like looking at a category of parliamentary or presidential systems. When you look at the actual institutional designs, there's a lot more convergence across those categories than one might think given the dominance that those categories have had in the literature. So one of the parts of this research program is to try to come up perhaps with new categories or to identify the way in which these hybrids are emerging over time. I'll take a student.
Do you think that perhaps the causation may work in a way that instead of the Constitution determining outcomes, the Constitution sort of reflects the values of the society? For example, inclusion, you look at Iceland versus Egypt, perhaps Iceland ended up with a more inclusive constitution because it has sort of more inclusive democratic cultural traits, while Egypt is a more religiously fragmented, tribal sort of society, and that perhaps trying to do in Egypt what they did in Iceland, perhaps might not translate very well.
Good, great point. I mean, so in general, we don't really know much about sort of best practices universally, and I certainly would not assert that it'd be a good idea to try the Icelandic approach in Egypt. I think that'd be a recipe for complete disaster. It works in Iceland because everyone's very educated, they're Nordic, so they all tolerate each other, although they have this long history of blood feuds as well. In Egypt, I think the best approach would actually be an elite level bargain, where you get the leaders of the various communities and and they really hammer out something which is likely to be sort of work for everybody. That's not at all what happened. It was one group just dominating the process. But whenever you have domination, you're not likely to get stability. And so I do think that one's normative recommendations do have to be tailored. So I accept the point. Martha?
Yeah, I wanted to ask about specificity, because it seems to me it's in a lot of tension with transparency. Mm-hmm. I was speaking enthusiastically in one class about the Indian Constitution, as I sometimes do, and a student who was from India but now in the US, he pulled out of his jacket pocket the document. And he said, this is the U.S. Constitution, and I can carry it around with me. I can look it up whenever I want to. I can know whatever's in it. If I had to do that with the Indian Constitution, it would be this huge book, right? And the result is that no one really knows what's in it unless they're extremely hardworking and educated. Now, of course, Americans don't know what's in the U.S. Constitution, but they could. And so I guess, I know you were talking about transparency ex ante, but ex post, if it's very specific, it does seem to militate against.
Well, that's certainly true, right? There's some sort of optimal level of specificity from the point of view of the society, and it might be different from the optimal level for a particular set of interest groups, right? So if I'm a kind of privately motivated person or interest group trying to get some benefits out of the Constitution, I want to make it as obtuse as possible so that no one can see what I'm doing. And indeed, the Indian Constitution is pretty hard to read, as you know. It's got sort of lots of cross-references and such, and as well as being something like 178,000 words. So so I think there is a tension there. Normatively, I'm not sure I'm convinced about the benefits of specificity. As a positive matter, it helps induce interest groups to support constitutional endurance. It seems to provide a certain level, that I think has an independent good and independent value. On the other hand, you want something from a normative sort of democratic theory perspective that can be understood by citizens. So maybe a tension between the positive and normative analysis here. Yes, in the back.
Are you tracking as one of your variables how constitutions are interpreted? So, for example, the conflict between originalists and people who view the purposes.
Yeah. So that's obviously a very interesting question and a major topic of sort of comparative analysis. Although, surprisingly, perhaps for Americans, originalism hasn't had much purchase outside the United States. In part, that's because in many countries the constitutional drafters are still alive and can say what they thought about things at the time. But in any case, one of the things about this project, and it's one of the sort of implications about looking at the Constitution as a product, is merely looking at the four corners of the document without trying to look at all the subsequent interpretations, or at least not to do it as systematically. And that's partly a practical decision. It's very difficult, obviously, to track how every particular rule of constitutional law has been interpreted across, even in one country, much less many others. But it's a kind of supplement, and there are other scholars who are working on that thing, which will be quite complementary, I think, to this work. Yeah.
I thought what you said about innovation was really interesting, but when I think about this, I would compare it much more to, rather than a product that you're selling, to something you own, like a home ownership. So people all the time make investments in their home, even though they can't recoup all that investment from the market. And I think then, if that's true, the big concern is more on the cost side and like the collective action problems. People are incentivized, but there's collective action problems. And that would mean we're probably more likely to see small little changes where people are making changes that they're really passionate about, rather than completely remaking it. So that, I guess my question is, do you think that's a valid metaphor? And also, are you doing anything to measure to what extent you can have changes that actually might change the Constitution through amendments or constitutional construction, to where we're really talking about a separate Constitution?
Good. Okay. So, conceptually, it's something I've been wrestling with. What is an innovation? Is an innovation actually coming up with something new that no one's ever thought of, or is it sort of packaging things that are already out there in new ways? And of course, this gets to some of the literature on design and such, and questions about where we grant intellectual property rights and where we don't, right? What kind of innovations we really want to encourage versus those that we think are going to function fine in the market. And it's one way to think about it is that every constitution which changes anything is a kind of new product. It's a new packaging of existing elements. One thing we can look at, and my similarity measures sort of suggested, is you can see how much any particular amendment changes a constitution versus a replacement. Turns out that replacements tend to be pretty large relative to amendments. Amendments tend to be very minor things on average. We can actually measure sort of conceptually the degree to which any particular amendment is introducing new elements. So I do think that's right. The metaphor works, and there's a certain amount of conceptual sort of fuzziness, if you will, around what's an innovation. When I look out there for things which are true innovations, which have never been adopted in any other constitution, which aren't being borrowed, those seem to be quite rare, and they seem to flow from really serious sort of ruptures in the previous society, significant social movements, and they can almost always be explained in sort of self-interest terms. Someone had to be very motivated to be an entrepreneur to bring in a new institution. But my general sense is there aren't very many of them. We ought to do much more experimentation. One I was thinking of is maybe no society's really ever experimented with the Greek solution of sort of randomly selected, citizens to run the thing. I don't know that we could do any worse in this country if we were to do that. So, but in any case, I believe there's a sort of suboptimal level. Anoop?
I had a question about measurement error, and particularly in your description of the U.S. Constitution, why you wouldn't recommend it. But I don't think that if you just looked at the document, you could get a proper measure of what the U.S. Constitution is. We have an enormous body of case law.
Yeah.
The document is incredibly, the constitutional law is incredibly specific. It's quite flexible because judges can do quite a bit to interpret, say, the Commerce Clause. So if that's the case, and that's just for the United States, that just happens to be the one that I happen to know a little bit about. I wonder what happens in other countries, and I wonder if it's a wise thing to use the text of the document to make predictions about what would work in other countries, even putting aside the comment from above about culture.
Okay, that might be right. It's clearly the case that part of the reason to focus on just the written text is a practical one, and also I think it's valuable in terms of comparability, right? Once you start getting into case law, one might look at the other sort of substitutes for the Constitution, which one could talk about. What are the unwritten norms that are operating in Zimbabwe that are constraining the government or not? And so there's, I think, value in looking at a discrete set of texts. The other thing is that Constitution makers aren't producing case law. They're not producing that whole body of constitutional law. They're producing texts. These are sort of discrete moments of purposive institutional design, and they occur in many countries, and I think we can say something just focused on them that will have some normative implications. Mike?
So early on you said something about that you observe little competition for constitutional product.
Yeah.
And presumably that may have something to do with immobility of people across boundaries. But capital's perfectly mobile, or can be perfectly mobile. So do you see any competition among jurisdictions with respect to constitutions on issues like property rights to try to create the most desirable location for capital?
Yeah, one would expect that, but I guess there's two things. First of all, there's a really good set of substitutes in terms of attracting capital. It's a set of institutions called bilateral investment treaties, and there's also, of course, some multilateral treaties which would do the same thing, where you provide for free flow of capital just at the treaty level. If you think about it yourself as a foreign investor, you don't really care what the local constitution says if you think you have a credible treaty right that can be enforced internationally. So there may be less pressure in a way to do that. One of the surprising things, though, that we found is that constitutions that promise greater property rights protection actually protect property less well. There's a negative correlation. And my only theory of that is that there's been a great deal of pressure on countries to improve their formal property rights protection. So countries that have poor protection are selecting into the population by increasing their property protection, when, in fact, as we know, to protect property requires a whole bundle of institutions, collateral institutions, which might not be available early on. Omri.
So imagine you wanted to study election systems, which work better or not. You would look at all the elections and see the type of results that they generate. But I imagine that you wouldn't count places where they run sham elections, where the Secret Service actually decides what puts in the ballot and who gets to vote. Even though formally they have a system, you would rule it out. And I have a little problem with the inclusion in your study of constitutions in places where it seems like a sham, in in North Korea.
Right. Well, the interesting question is, I think it's an empirical question, to what degree a constitution is actually a sham. One simple approach might be to say, only look at democracies. But it turns out that constitutions actually do matter in many dictatorships. The rules for executive selection, for example, Mubarak, Sadat, they spent a lot of time tweaking their constitution in order to get certain benefits. By the way, one of the reasons Egypt's a kind of disaster today is they had to do a deal with the Muslim Brotherhood at one point in order to get that through. Even in a dictatorship, they were constrained a little bit. And the Constitution did matter in terms of some things, maybe not rights protection, but in terms of executive selection and things like that. Now, in a country like North Korea, I'm sure it is a total sham. It literally has no meaning or no actual application. Though that itself is a kind of interesting question as well. It's like, why then is it produced? Even dictatorships are spending significant political energy on it, and sometimes we don't know really what their motives are. The Burmese government, which I mentioned before, took 17 years to draft the constitution, which emerged in 2008. I and everyone else thought that this was just a sham constitution. It turns out to have been the culmination of an invisible process whereby a decision was made to liberalize. So I actually think those are the ones which may be most important to look at, because we'll be able to sort of try to figure out what clues we can see about the society in what are generally very obtuse or obscure situations. Yeah, with the hat.
Yeah, my fellow student's question piqued my interest in the difference between the cup maker and the actual design of the cup. I was wondering if you have any sort of statistics saying their relative, or judging their relative importance, whether, you know, Iceland is bound to make a more successful constitution just because it's the people of Iceland than the people of Egypt, even if they do everything right and they spend a year on it, versus the people in Iceland spend like a week doing it sort of ad hoc.
Yeah. Well, there's intuition, of course, which says, you know, again, evaluating what's good and what's bad is very difficult outside of the context. We don't know if the fact that Iceland's last constitution lasted 60 years was a result of it being a good set of institutions, of the people being Icelanders, or some interaction of the two, right? And so it's a bit hard to isolate exactly what would be making the difference there. But the so one way to look at it is to take designs and look across cross-sectionally how they are functioning in different countries. And that's one thing that I suppose this research program is trying to address, is to look at a set of like countries, and then where you might have some different institutions which vary, right? And then that will allow us to make some inferences, I suppose, about the efficacy or the quality of the institution. But I don't want to deny that there's something that we might call a constitutional culture, right? That people do have their set of preferences and their social conditions, which are likely to make some institutions work better or worse. That seems to certainly be the case. Jeff?
If you were called in as a consultant to advise a generic country that was about to draft its first constitution, which of the three existing constitutions you would draw upon most as your models, and why?
Which of the three?
Yeah, which of the three that exist would you draw upon?
I'm sorry, the three
You were
models?
called upon to help draft a constitution.
Yeah, South Sudan, newest country in the world, right?
What is it?
South Sudan.
Okay. And the question is, which three constitutions that now exist?
I see. Oh, which would be the model? Okay, so that's a good question. Well, first of all, I'm generally a fan of a kind of generic parliamentarism. I think it's really good for societies which have lots of different ethnic groups like South Sudan does. So I think that's good. I would say Germany, it's a very influential model, good constitutional court and all that, but I'm not sure that that's likely to suit a country like South Sudan, which doesn't have a grand legal tradition, doesn't have a lot, can't really tolerate a very complex constitution. So I might say something much simpler. Actually the Icelandic one is one I kind of like. It's pretty short. It's easy to understand, to Martha's point. It features a lot of popular involvement, not only a lot of rights, but a lot of opportunities for the people to influence major decisions and things like initiative and referenda. And I think that's a pretty good model, even for a very poor country like South Sudan. Maybe especially for a poor country like South Sudan, because one of the challenges the country faces is to get everyone to think of themselves as South Sudanese. And if you've got a kind of mechanism where they're forced or encouraged to be involved in ongoing government, I tend to think that'd be a pretty good model.
And I take it, though, for a nation with a long legal culture that's fairly stable, that Germany's the one you...
I like Germany. I think it works pretty well. Maybe it's because they're Germans, but I'm a fan of the German Constitution. You asked for a third, so now I have to come up with a third one. Yeah, a lot of people are big fans of the Canadian one. I don't think it's that great.
The cultural historian Michael Kamen wrote a book about how the Constitution has manifested itself in popular culture, looking at media representations, journals, and so forth, just to get a sense of how a document permeates the popular culture. Have you kind of tried to measure that at all?
You know, one of the major challenges of this in general, right, when you're trying to look at constitutional efficacy, is the lack of good sort of dependent variables, if I could call them that, good indicators of constitutional performance. We rely on these political science ones. They've got lots of measurement error. They're sometimes crude and sometimes subjective. So in the era of big data, I think there's great opportunities to try to get at this in greater depth. So imagine if we could, for example, survey the number of mentions of the Constitution in newspapers in particular countries and times and places. That'd be a pretty good indicator of how important it was for popular consciousness, right? There are various surveys also, you know, values surveys, world values survey and such, which might get at this a little bit. And there's actually a new effort promoted by the American Bar Association, of all organizations, to try to measure the values of the rule of law in a whole bunch of different countries. So there's more and more dependent variables which allow us to get at that. I don't have a good one now, but I'm looking.
One more.
Ed.
It may be too late in the day to ask this question, but I wonder, what is a constitution?
Yeah.
So, because when you compare across countries, some have much slimmer constitutions than others, but the longer ones cover rights that are often covered by statute elsewhere.
Yeah.
I know the Cuban Constitution has lots of provisions that are covered by statute here in the United States. And the process for enacting legislation in the United States might mean that once a statute is enacted, it's actually pretty difficult to get rid of it, so that it tends to have the durability of a constitutional provision. So as you compare across countries where it's not obvious what counts as a constitution, because there might be things like statutes that function much like a constitution. So I wonder, how do you handle that in the project?
Well, so it's a great question. It goes to the issue of substitutes. You know, there's an old joke about someone who goes to the library and asks for a copy of the French Constitution and is told by the librarian that they don't stock periodicals. And if you go talk to French people about their constitution, it's not like talking to Americans where we treat it as this, you know, quasi-religious document handed down by God on the seventh day, right? There's a much more, there's a sense that the Constitution is just about the politicians, really. And the fundamental things that govern French society are things like the French Declaration of the Rights of Man, the administrative law regime, which is governed really since the ancient regime, actually. And so there's a lot of stable institutions and a lot of sources of rules which don't have anything to do with the Constitution. That's a generic problem. That's the problem of substitutes. I suppose my only answer is to say that until we have a good, you know, handle on the formal Constitution, we can't do a systematic comparison of what, even if we can measure them, all the actually operative rules were with the formal text. What percentage, if you will, conceptually, of the truly small c constitutional rules are contained in the formal text? That's a question I'd like to answer. But until we got the first measurement, or the second measurement, now we can't do the first. So.
Thank you.